from the list notes that the improved order has already been decided by the trial court notes. So my only submission that the second appeal, I am on behalf of the different notes. This second appeal has become infructuous. So it is at serial number 35 from the list notes.
Who's for the appellant?
Sorry.
Who's for the appellant?
Amar Kumar.
To call you?
Yes, sir. I call my only submission that it may kindly be taken up in a second. I'll have already.
Call you उनके बिना सुन के हम क्या this infructuous करेंगे? Why has it become infructuous like that?
Lord's reason being that one this case was being filed in the title suit, and subsequently against that an appeal was being preferred, first appeal, and there that from that appeal the second appeal lies. Okay. But the title suit has already been decided in favor of the defendants, in which that this case was preferred subsequently the second appeal.
I don't think that.
Because the case is basically the defendants are the owner, and subsequently an eviction suit is being filed.
Let us see.
Yes.
Let's see the record. वो record निकलवाइए समाधों को.
जी.
From the daily list, targeted case and heading for orders, item 1, second appeal 283 of 2004.
Yes.
Last date I made a mistake.
What mistake?
That wrong application was filed, and thereafter going through the worship, it was my mistake. Going to that finally time best to file the application. Bringing because there was substitution.
What mistake? I am not able to get which order.
Lordship, last order.
Last order date बताइए.
Date the Lordship 8th of.
So what was the mistake?
Actually, what IA has been filed by
For addition of.
Yes.
Yes. Then I have not disposed it of. It is pending.
Yes, Your Lordship.
So
Thereafter, I filed the application. Subsequently, I filed the application, appropriate application for setting aside the abatement, for bringing on legal heirs and delimitation. So these are the briefs of my IA, Your Lordship, that has been filed. That wrong
how
application.
many IAs have you filed?
Your Lordship, there are total, as on date, Your Lordship, there are 5 IAs. All the 5 values are fixed. Your Lordship, first IA was 539 filed by the respondent. They said the respondent number 3 has expired, so these are their legal heirs.
Okay.
And respondent number 2 and 4 have expired, and their legal heirs are already on the court. And thereafter 6659 on 2025 was filed by me. Inadvertently, I filed out addition of.
So you want to withdraw this?
Yes, I have filed the appropriate action for withdrawing this application.
Okay.
Thereafter-
IA for withdrawal.
Withdrawal is Your Worship, withdrawal is 12809.
That's it.
And 12807 is for theft.
That's right. And ID number 12818 is the order for
Limitation for condoning the delay.
condoning the delay. Where is the petition for substitution then? There is no petition for substitution.
I have filed the petition.
What is that ID?
I
What
number is
substitution?
12807 of 2023.
12807.
Yes.
Achha, okay. Abatement along with 44. This is with respect to respondent number 3. Any objection to this?
Lordship, only delay point, Lordship, I am objecting because after going through the entire document, there is no sufficient cause has been shown. You can condoning the delay, Your Lordship, and setting aside abatement.
2004 से यहाँ pending चल रहा है.
Yes, Lordship.
2004 the matter is pending already.
Yes, Lordship.
Who are the legal heirs of respondent number 3? Will you represent legal heirs of respondent number 3?
No, Lordship, I have filed a IA through which I have given details of the heirs of respondent number 3, legal heirs of respondent number
When did you file that IA?
3. Your Lordship,
IA number 539 of 21.
yes, Lordship. 2021.
फिर ऐसे number 283 of 2004. The learned counsel for the appellant has submitted that following IAs are pending for consideration. IA number 539 of 2021 is the order. the interlocutory application bringing on record the information regarding death of respondent number 3 and his legal years and also death of respondent number 2 and 4 stating that their legal years are already on record has been filed by the respondent.
Yes. For respondent number 4, I have not given any information, Lordship. Only regarding respondent number 2 and 3, I have given information.
तो 4 कैसे लिख दिया?
4,
Why have you written 4?
I don't know.
Because
If Lordship will see the order dated 10/12/2020, then Lordship picture would be clear because by the order dated 10/12/20, I have been informed to give information regarding death of 2, 3 and 4. Lordship actually
Para
I was
seven,
appearing
para
for
seven.
respondent number 1 and 2.
para 7 you have stated that respondent number 3 has died, right?
Yes.
And then you have stated that in para number 4 you have stated that they are already on record. In para number 7 you have stated that it is stated that so far as legal years of respondent number 4 is concerned, the details of the deceased respondent number 4, that is his date of death and his legal years, could not be ascertained in spite of best of efforts. Whereas he stated that legal years are already on record. Tell me. Where has he stated that legal years are already on record?
I am not on it.
That means
कुछ भी लिखते हैं भी आपका तो भरोसा करके कोई ऑर्डर नहीं कर सकता. अननेसेसरी सुबह सुबह जो है ना 10 मिनट वेस्ट करते हैं. गलत समेशन. ये राइटिंग में आप देखिए. Where is it stated that the legal years of respondent number 4 are already on record? No. Date of death also. Are you aware that he is dead? Are you aware that he is dead?
No, Lordship.
Where have you stated that that you are not aware whether he is
Yes,
dead or
yes,
alive?
Lordship. In my IA.
Yes.
In my IA paragraph number 7, Lordship.
Yes, para 7,
Page number 5, Lordship.
page number 5.
Yes.
Yes. Date of death you could not ascertain, but he is dead. Where have you stated that?
Lordship, actually on that time, perhaps on the order dated 10/12/20 passed by the Honorable Court, on the basis of office note it was ascertained, maybe Lordship, that respondent number 4 has died because notice was issued. And on the basis of service report, Lordship, I have been informed to inform the court regarding death of these 2, 3 and 4. But I have given information regarding 2 and 3. But I could not gather information regarding respondent number 3.
Respondent number 3 and 4.
Not necessary, respondent number 4.
Where is the substitution of respondent number 4? तो खत्म हो गई. Story over. फिर से लिखे थे. essay number 283 of 2004. Counsel for the parties are present as per order dated 10/12/2020. It has been recorded that as per office note in connection with service of notice, respondent number 3 and 4 have expired. it was also reported that respondent number 2 had also expired
Yes,
by the respondent.
yes, yes.
On that day, the counsel for the respondent had submitted that he shall file application under order 22 Rule 10A CPC informing this court regarding the name of legal years of respondent number 2.
Yes. As well as
And
four
he
also.
shall try to take information with regard to legal years of respondent number 4 and his date of birth.
Yes.
The counsel for the appellant was directed to take steps for substitution of legal year of respondents who died during the pendency of the appeal within a period of 30 days after the physical court starts. The learned counsel for the respondents has submitted that accordingly a petition under order 22 Rule 10A CPC has been filed, being IA number 539 of 2021, wherein it has been reported that respondent number 2 has
Para 3 and 4.
it has been reported that respondent number 2 has died during the pendency of this appeal and his legal year,
Brother respondent number 1
namely respondent number 1,
yes,
is already on record.
Yes, yes, Lordship.
So far as respondent number 3 is concerned, he had expired on 26/9/2009 during the pendency of this appeal, and the name of his legal years and successors have been mentioned in paragraph 6
Yes,
thereof. In view of the aforesaid statements made with regard to respondent number 2, the counsel for the appellant is directed to delete the name of respondent number 2 from the first title, and it is recorded that the legal year of respondent number 2, that is respondent number 1, is already on record. Okay, we are ready during the course of it. With respect to respondent number 3, a petition for substitution has been filed, being IA number 12807 of 2025, and another petition for condonation of delay has been filed by IA number 12818 of 2025. The learned counsel for the, however, so far as respondent number 4 is concerned, no petition for substitution is made. And it is not in dispute that respondent number 4 has expired. In view of the aforesaid circumstances, the proceeding has abated as against respondent number 4. So far as respondent number 3 is concerned, earlier one application, the IA number 6659 of 2024, was filed for addition of party of the legal years and successors of respondent number 3. The counsel for the appellant has submitted that the said petition was inadvertently filed, and accordingly a petition for withdrawal of the said petition has been filed, being IA number 12809 of 2025. The counsel for the appellant has submitted that the IA number 6659 of 2024 be permitted to be withdrawn, and since an appropriate petition for substitution of respondent number 3 along with petition for condonation of delay and a prayer for setting aside abatement has already been filed. Considering the aforesaid submissions, IA number 6659 of 2024 is permitted to be withdrawn, and in view of the fact that the same appears to have been inadvertently filed. Consequently, IA number 12809 of 2025 is allowed. ये दोनों IA खत्म हुआ. So far as IA number 12807 of 2025 and 12818 of 2025 are concerned, let notice be issued to the proposed legal heirs and successors of respondent number 3 for which requisites under कहाँ के हैं Ranchi के for which through the concerned police station for which requisites be filed within a period of and also under speed post through the concerned police station and also under speed post for which requisites be filed within a period of 1 year. दोनों IN ठीक है 12807 of 25 and 12818 of इसमें आप close this case on of October 25 to awaiting service report. In the meantime, it will be open to the respondents to file their response to the proceeding. That is IA number 539 of 2021 is also closed.
Item 2, second appeal 36 of 2004 along with item 3.
Lordships, in item number 3, Lordships has given direction to file वकालतनामा Lordships. So Lordship, I obtained वकालतनामा to date, so तो लोग आज ही आ पाए हैं Lordships.
Item number 3, SA number?
SA number 108/2005 Lordships.
Whose वकालतनामा have been received?
Lordship, for substitution I filed 3 IAs
Who
Lordship.
had given direction? By which order?
The last occasion Lordship, it was directed to file वकालतनामा on behalf of proposed appeal number 12 Lordships. Because 3 IAs are
That's appeal number 12. In connection with appeal number 12, 3 IAs are pending. You file and come. File your IA, we pass appropriate order.
The IAs are pending, so I will file वकालतनामा today.
You get it ready, file it before the board, we take it and pass them.
And one more thing, one more prayer, Lordship. Respondent number 1 has died, Lordship. So for substitution of the same.
उसी समय order करेंगे. Respondent number 1 has expired. When did he
In
expire?
both of the cases, respondent number.
When did he expire?
अभी हमको बच्चे ना डेट नहीं पता नंकेश्वर इन लोग के केसेस में सब्स्टिट्यूट हो गए थे केस में मेरे में नहीं लॉर्डशिप्स तो उनको नंकेश्वर महतो हैज डाइड
Nankeshwar Mehto. Are you appearing for Nankeshwar Mehto in any of the case? Respondent.
Respondent 28.
हम लोग
वो Nankeshwar Mehto पे किसी लीगल हियर की तरफ से आप
I
appear हो रहे हैं?
am on behalf of the Nankeshwar.
In one of the cases.
Appellant is the Nankeshwar Mehto in the first case.
In first case.
Yes.
So will you seek instructions?
Yes, I will file वकालतनामा.
Because he has been he has expired and has been substituted
In the
one
first,
of the
yes,
case,
I have no
first
objection.
case.
If simple petition, if
So
they file,
why are you not filing petition?
यस सर आज ही बच्चे लाइन फाइल कर देंगे
तो फाइल करी. अब उनका नाम लीगल हियर का
सब दे देते हैं. सब details है. And I will also appear on their behalf.
ओके. यही तो कोविड में तो सब इंटरलोकेटरी एप्लीकेशन सब पढ़ाई.
हाँ, सब पढ़ा हुआ है.
पहले रिस्पोंडेंट नंबर 12 का आज ऑर्डर कर देते हैं. लेट अस ब्रिंग द वकालत.
Yes.
आप आइए वकालतनामा लेकर 12 बजे तक आ जाएंगे.
Yes, so वकालतनामा is ready, Rashid, to start लगाने हैं. आ जाएंगे 12 बजे तक.
आ जाइए, स्टैम्प लगा के लेकर आइए. नाम वाम में गलती नहीं करेंगे प्लीज. हाँ, बी वेरी वेरी केयरफुल. टेक केयर योरसेल्फ. मुंशी को मत दे दीजिएगा. एक ही जगह ओ लिखा जाएगा तो डिफेक्ट लग जाएगा वकालतनामा का. फिर आपको फ्रेश वकालतनामा फाइल करना है. कोई एलियस नेम नहीं देंगे. ठीक है? You come at 12.
From the daily list under heading for final disposal item 4, second appeal 293 of 2017.
You should identify for pending additional substantial question from.
It is a respondent. Somebody was appealing.
Yes. Suit was for eviction under the Rent Control Act. Is a finding the trial court that there is no atonement of landlord relation tenant, landlord and tenant relation. Initially, what happened in addition?
What additional substantial?
Yes. I hear your worship.
When did you file it?
Well,
बुला रहे हैं. Who was appearing on the last date? Mr. Amit Sinha.
Mr. Amit Sinha Jr.
Since you have filed it, they will respond to it. If they want to, they may respond to it.
Leadership.
Anyways, what additional substantial document?
Yes. Now, the suit was for eviction on the ground of default and personal necessity. I'll just give a brief background. The suit property was leased out to the defendant on 5th of July 2001 by the husband of plaintiff number 1 and father of plaintiff 2 to 4. It has been averred in the claim that the tenant has defaulted on payment of rent since September 2009. And the original landlord, that is the husband of plaintiff number 1, he passed away on 4th of February 2010. So the learned trial court and the lease was for a period of 28 years. So the learned trial court has held that since during the lifetime of the father of the plaintiff 2 to 4 and husband of plaintiff number 1, he did not take any action for eviction of the tenant because the default was during that period. And since the rent receipts which we have had filed was during the lifetime of the father, so there has been no atonement of relationship of landlord and tenant. That is one question on which my suit was dismissed. Second, it has been held that second, that since the lease provided that no action can be taken or rather the tenant will not be treated as defaulter even if he has not paid rent for a period of 4 months. So therefore, after 2 months, he cannot be held to be a defaulter in the event he has defaulted in payment of rent for 2 months. On these grounds, my suit was
There
dismissed.
can be yearly tenancy also.
There can be early, but
They can be 6 months.
this was this. There can be lease period can be of 11 months, can be of 10 years.
No, it's not a matter of lease period. One can agree through an agreement that the rent has to be paid on
That is precisely the question of law we have framed. Your leadership is fine. The Act says no withstanding anything contained in any agreement.
There is a non-obstante clause.
So you want to say that this particular clause is redundant.
Yes.
The lease agreement is of the year.
2001.
So this provision of default of continuous 2 months has been there since 1981.
1980.
Yes.
In not in conservation this we not able to come.
You have not circulated any advances.
Message
Just message me. This is serial number 4. Direct transfer for the parties at present. IA number?
12840. Okay.
IA number 12840 of
25.
2025 has been filed proposing additional substantial question of law. The learned counsel for the respondent seeks adjournment to prepare himself on the additional substantial question of law. Pose this case on next one.
Good.
Item 5, second appeal 231 of 2018.
Where is the appellant? The matter was substantially heard on 9/7/2025 and was directed to be posted on 10/7/2025 for further argument of the counsel for the appellant. आपने
Disconnect.
आपको क्या लगता है?
Noting both the court concurrently held that there is no relationship of landlord or tenant between the plaintiff and defendant.
Substantial question of law देखें हैं.
हाँ देखें लॉर्डशिप देखें.
Concurrently held, but they have taken into consideration the written statement and the evidence of the defendant. Would they take it, even to hold it against the defendant? When they take that into consideration, or plaintiff has to prove his case? You see, defense is structured.
Yes. But so far the weakness of the plaintiff lordship can reduce evidence lordship. There is a judgment. There is a judgment of 1989 Supreme Court judgment.
कहाँ है?
1989 judgment. Yes, I am showing lordship.
ये तो जो मॉड्यूलर
Modular.
हाँ तो वो तो इसमें सब्सटेंशियल क्वेश्चन ऑफ लॉ में ही लिखा हुआ
हाँ लिखा हुआ है.
है. आप दिखाइए वो चाहे
हम लाएंगे इसमें दिखाएंगे. मोडुला से ही दिखा रहे हैं.
आप जितना लिखे हैं ना.
Sir.
Suppose this case for since the appellant is absent, respondent is present. Post this tomorrow. कल नहीं आएंगे तो उनका केस डिस्कस कर लेंगे. एक मौका दे देते हैं.
जी. ये जजमेंट और लॉर्डशिप हम दे देते हैं.
दे दीजिए, आपको 2 जजमेंट देना है. कल है ना 10:30 में आ जाएगा एट 10:30.
जी.
आप उनको मिस हो लीजिए, मैं आपको खबर देंगे. लास्ट टाइम वही अपीयर हो रहे थे
जी
ना.
वही होती है.
आप कर देंगे खबर उनको.
हाँ सर.
Item 6, second appeal 241 of 2018.
Yes, you have 5 minutes.
Just play for short passover. The arguing counsel, Mr. Rahul Gupta, is on legs in court number 16. Just passover for
You start your argument. Let him come. You start.
But we have the substantial portion from
Yes. It was already framed.
my lord. I am permitted to read, my lord.
You read the case of assassins. Okay, read the substantial. Yes, please. Read it.
Whether learned first appellate court has committed travesty by holding that the sale deed disputed by Laduna Hope in favor of the mother of the plaintiff is barred by provisions of the Chota Nagpur Tenancy Act, even though there is no such meeting of the parties. Second one, whether the first appellate court has committed gross illegality by observing that the plea of adverse possession can be used as a shield and not as a sort of view of the principle of law settled by the Honorable Supreme Court of India in paragraph 64 of the judgment in the case of Ravinder Kaur, Grewal and others versus Manjeet Kaur and others reported in 2019 8 SCC 729. Third, whether learned first appellate court has committed travesty by excluding Exhibit 5, which is relevant material in arriving at the finding. Fourth question of law is whether learned first appellate court has committed gross illegality by holding that the suit is barred by limitation in view of the principle of law settled by Honorable Supreme Court of India in paragraph 18 of the judgment in case of Daya Singh NR versus Gurudev Singh by Alas and others reported in 2010 to SCC 193.
These judgments which have been mentioned in the substantial question of law, give me these judgments. But Daya Singh is here. What about this one? That law is well settled. Now let you read the read the High Court judgment. What was the suit for?
Seniors.
What was the suit for?
Yes.
It was a title suit and for a declaration that the entry is incorrect.
Yes, your Lordship, only 2 minutes. Your Lordship, please. If your Lordship would take up the trial court judgment,
Yes, I'm there.
which is at running page 24.
Prayer is quoted.
Yes, prayer is quoted for a decree of declaring the right title interest over of the plaintiff over resource property, and then for declaring that the settlement entry in respect of the scheduled rank of the plaintiff in the record of rights finally published on so and so, showing the khata in the name of one Bihar Sarkar is wrong and erroneous, for permanent injunction restraining the defendant from interfering with the peaceful possession of the plaintiff over the scheduled land in any manner whatsoever, and also from taking possible possession of the same or part any.
So there is no prayer for recovery of possession.
No, because we are already.
Yeah, you are already.
Yes.
Let's see. What is the case of the parties? Read
Now,
it from the
Facts have been stated in para 2.
Can you read?
Yes. That the case of the plaintiff, as per her plaint in brief, is that the land measuring an area of 0.40 hectares in plot number 2988 and measuring an area of 30.60 hectares in plot number 2989, both plots under khata number 909, situated in so and so, Mangal Notified Committee, Ranchapur, so and so, with house and premises standing thereon, more fully described in schedule of the plaint hereinafter, referred to as suit property in the subject matter of the suit, land is within the jurisdiction of this court. Further stated that the suit land is in actual physical possession of the plaintiff since long from 8/8/1956, and the mother of the plaintiff, late Masi Dhani Tirki, wife of Joseph Tirki, had purchased the suit property from Nathura Ho, son of Hado Ho of Mango Jamshedpur, district Isunu, by virtue of a registered sale deed number so and so, dated 8/8/1956, and since then she, along with her family, started residing thereby constructing house without any interference or objection from any corner. After the death of Matsi Dhani Tirki, the plaintiff, being the daughter, inherited the suit property and she continued the possession thereof without any objection. It is further stated that the enforced possession of the plaintiff and her mother Srimati Masi Dhani Tirki over the suit land was all along remained free from any obstruction from any corner whatsoever, and they, by their enforced act of possession, acquired their indefeasible indefeasing right, title and interest, as well as possession adversely as well within the knowledge of all concerned. While in possession of the suit property by the plaintiff on 15/4/2005, one person claiming to be the staff of Forest Department threatening the plaintiff to dispossess her from the suit property on the basis of wrong and erroneous entry in the record of right, finally published on 10/8/1979. After the aforesaid threatening given by the forest staff, the plaintiff for the first time came to learn that the suit property has been wrongly recorded in the name of one Bihar Sarkar. Thereafter, plaintiff searched and inspected the record of rights in respect of the property in the office of record room and could know that the suit property is wrongly recorded in the name of one Bihar Sarkar, and the same is shown in the remarks column, illegal possession of Masi Dhani Tirki, wife of Joseph Tirki, since the year 1971. It is further stated that the suit property is in actual physical possession of the plaintiff since long more than 48 years from the time of her mother, since 8/8/1956, without any interference, and the plaintiff has acquired indefeasing right, title and interest thereon by virtue of adverse possession well within the knowledge of all concerned. The plaintiffs have been performing all her acts of possession of the suit property since more than 48 years without any hindrance from any corner thereby. Her possession and the title over the suit property have been duly confirmed under the provisions of law. The defendant, this is one important, the defendant filed case under section 83 of the CMT Act with respect to the suit plot against Masi Dhani Tirki, mother of present plaintiff, by order dated 24/8/1973. The assistant settlement officer has confirmed the possession of the plaintiff and plaintiff's mother. Further, the plaintiff has already filed original holding tax receipt of Mango Notified Committee in support of the fact that the plaintiff is in possession of the suit property since long, and that her name has also been mutated in Mango Notified Area Committee. Further stated that one Bihar Sarkar has no manner of possession over the suit property or any portion thereof at any point of time. It is further stated that the plaintiff sent notice under section 80 of the CPC upon the defendants on 3/5/2005 and thereafter on 12/5/2005 for settlement of the suit land with plaintiff, but they refused for the same. Plaintiff is entitled for a degree of declaration of her right, title and interest and possession of the suit land, and further entitled for permanent injunction restraining the defendant from interfering the peaceful possession of the plaintiff over the suit property. That the cause of action for the suit arose on so and so, and then the description of the land is there. Then the written statement and the challenging the enforced suit of the plaintiff, defendant number 1 and 2 have filed his written statement jointly, and it is pleaded that the suit is not maintainable in its present form or for the relief claim. The plaintiff has also got no cause of action, and the suit is barred by limitation and section 80 of CPC under the provisions of CMT Act as well as BLR Act, Specific Relief Act, waiver, estoppel and acquiescence. It is further pleaded by the defendant that plaintiff has not justified his physical possession on the suit land since 8/8/1956. The land under ex-landlord Raja Jagdish Chandra Dhaval Dev, and after Zamindari abolition, the entire land of ex-landlord under PLR Act 1950 is vested with the state of Bihar and now state of Jharkhand, and the state government becomes paramount owner of the property with intermediary interest. The state government has got all right, title and interest on the suit land. After vesting of the land, the ex-landlord, there was a khanapuri and record of right in
I
respect
have
of
got it. That's right. So basically, you claim that you are in possession since 1956 on the basis of a registered sale.
registered deed, and my possession has been recorded as illegal in 1971. But despite and against that, the state files an application before the settlement officer that is rejected. Then also I continue to be in possession.
No, just a moment. Prior to that, under section 83, you had filed an application.
I have not filed. It
Okay,
is
so defendant had filed.
yes,
an
yes.
application.
The state.
That's not rejected.
Yes, yes.
And you continued in.
Yes, yes. So my possession from 1956, it was first time recognized and entered in revenue records in 1971. And though it was noted as illegal possession, then also when the objection was made by the state with regard to that entry, it was rejected. Then it was for the state to have taken filed a suit for recovery of possession, and that was never done.
Recovery of possession or maybe by an appeal against that.
Whatever. But
83 has an appellate remedy also.
yes, yes.
It has an
But-
appellate remedy, it has a second appeal also.
Yes, yes.
Those remedies they did not choose to exercise.
So yes, so therefore
Nor did they file any suit.
no. So because I was in possession, therefore they were also required to have sought for recovery of possession from me. So they do not do so. So what is the consequence is that the order passed in the 83 CNT Act that even saying that I am in illegal possession, that attains finality. I am in possession. Undisputably, I am claiming my right on the basis of a registered deed executed by my
So
predecessor.
according to you, your possession will be counted from 1971.
No,
Or
it
it
is.
will be
It would be
counted
from 1956 because it is.
What
in,
is the act of possession since 1956?
I have constructed house. I am residing there, and
Is there any
therefore
finding that you are in possession since 1956?
that
And what
date
were
is
the-
not given.
What were the issues framed? And which issue would be relevant?
Yes.
Roman 4 and Roman 3 perhaps,
Yes.
right? Because limitation is another issue which you have raised on the basis of dias.
Yes. So 4 and 5, if your lordship may only allow me to place, and then
4 and 5 are taken up together.
yes.
The latest in your 5-year sale deed, yes, it is there. Any rent receipt thereafter?
Rent receipts are also.
Not found. Punch mail receipt. What is punch mail receipt? Defendants did not produce any oral and or documentary evidence.
No. They do not.
Okay, where is the exhibit?
But then
of
also
your,
I say that I have to because I am the plaintiff. I have
that's
to.
it. Where is the exhibit of your 83 order?
Exhibit 5.
Exhibit 5.
This is the reason that the predecessor on
Exhibit 5 with that basis.
it was admitted on this point because there was an order of 83 which was remained unchanged.
Now let us see the findings.
Findings, your lordship,
It's
issue
a long
number
chapter.
4 and 5. I can read all, but your lordship, actual finding.
Yes, yes, please come to that. We have seen the respective cases.
He discusses the witnesses, and then your lordship, internal page 7, running page 30, page para 6.3. May I place only a relevant?
Yes, yes,
portion of-
only the relevant.
Your lordship, 6.3.
Yes.
In support of her case, plaintiff has filed and exhibited some documents Exhibit 7 is certified copy of Khatiyan of so and so under ward number 9, notified area Jamshedpur. On perusal, it appears that Khata and plot number mentioned in the Khatiyan is the suit land of this case. Khata number 970, 2988 and 2989 is recorded in the name of one Bihar Sarkar, and column number 7 of Khatiyan. Illegal possession of Masjid Hani Pirki has been shown since 1971. This Khatiyan is finally published on 31/8/1979. Exhibit 1 is the sale deed dated 8/8/1956 executed by one Nadura Ho in favor of the mother of the plaintiff. Sale deed Exhibit 1 is in Bangla language, so its certified English version has been filed for the perusal of the court. The land mentioned in the sale deed related with the suit land is admitted fact by both parties. Exhibit 2 and 2/8 are carbon copies of notices issued to the Deputy Commissioner East Singhu, Secretary so and so under Section 80 of CPC. Exhibit 3 and 3A are postal acknowledgement card in respect of Secretary so and so. And Exhibit 5 is the certified copy of the order passed in case number 2268 of 72/73 under Section 83 CNT Act, passed by the Assistant Settlement Officer Singhu. It appears that the state had filed this objection case against the mother of the plaintiff with respect to the suit land, which was ultimately dismissed. Exhibit 6 and 6/C are Panchmail receipts issued by Mango notified
What is
area
the date
committee.
of exhibit 6?
So here your lordship was in here. I have twofold contention. First, if your
These
lordship,
are of much later date.
yes. And if your lordship, this is the exhibit 6 series which your lordship
Yes.
wanted to know.
There are
This
much
is-
later date.
Yes, this is 76.
But the after 71. None of these documents are prior to 71.
No, sir.
Oral evidences have supported that you were in possession since 1956.
Yes, that is there. Later, but therefore I made two submissions. That let us assume that there is no evidence whatsoever even prior to 1971. Then also the effect of the order passed by where in 71 my illegal possession is being recorded, and then also till date no suit whatsoever. So what would be the effect of that? Because 71, 12 years after the objection was rejected, 12 years have also passed.
Is there any order passed asking you to give possession to them? ऐसा तो reverse order तो नहीं होगा.
नहीं, मेरा इस केस में my suit has been dismissed and appeal also has been dismissed, and strangely making out a case that I had failed to produce the permission by which the DC had granted permission from the transfer in 1956. Strange, and both the courts take the same ground. One, without there being any plea of violation, and both were scheduled trial. So unless and until it was raised in the original pleading, then only I could have shown as to whether it was there, whether this would actually 46 violation was there or not, whether it was a Rayati land, and whether permission was at all taken or not. This only could have been produced by us if it was actually raised.
There was no mention of the permission in the sentence.
That
Like the exhibit number concern
Say
normally रहता है.
हाँ ठीक.
Exhibit 1, that is Bangla.
Exhibit 1, 8890.
उसका English translation की हिंदी translation कुछ तो फाइल हुआ. ऐसा कोई परमिशन का बात है इसमें नहीं।
Only one thing I must be clear about, Your Lordship. It appears that that Exhibit 5, initially it was allowed in favor of state, and then on the application filed by the defendant, this was recalled and that order was recalled. Therefore, ultimate effect is that the application or objection of the state was rejected.
That
By
order
the-
was recalled.
No, initially it was that order was by this the objection of the state was ultimately rejected. But it was on our objection.
I don't read it.
Your Lordship
So
may
they
kindly
filed
see.
an objection and the
Your Lordship may kindly see Exhibit 5. because-
Yes, I am there.
Yes. Your Lordship may kindly come to the last portion, where the last portion of it. Because initially the defendant of that suit, that means the plaintiff here, they were not appearing, and then it was said that Your Lordship has got internal page 3 of that order sheet.
1, 2, 3. There are 4 pages.
हाँ.
Yes. प्रतिवादी की अनुपस्थिति। यही? Exhibit 6. You are referring to Exhibit 5. No?
The second last paragraph of internal page 3.
Yes.
प्रतिवादी के अनुपस्थिति के कारण दावा एक पक्षीय निर्धारित बदर सुइंसो से खाता बनाया गया है। प्रमाण में केवल 1956 का केवला प्रस्तुत किया गया। गैर मजरूआ जमीन का उनका बंदोबस्ती बिना बंदोबस्ती के प्रमाण का उल्लेख कहीं नहीं है, अतः वादी का दावा साबित के आधार पर मान्य ठहरता है। देन दावा स्वीकृत सो खाता से विलोपित कर अंकित करें एंड देन तथा अवैध दखल मसीह धानी तिर्की सन 1956 लिखें। देन नेक्स्ट पेज उपस्थित केवाला संख्या 1956 द्वारा लादूरा हो से मसीह धानी तिर्की ने मानगो इतना 1 बीघा जमीन खरीदा। विक्रेता लादूरा हो का टाइटल अपील में स्वत किया जा चुका है। प्रमाणित प्रतिलिपि सन 1956 में बना जो मेरी अनुपस्थिति के कारण में खाता प्रविष्ट हुआ। प्रतिवादी के अनुपस्थिति में दिनांक 8/8/1973 को एक पक्षीय विचारण कर निर्णय दिया गया था, जिसके फलस्वरूप वादी का दावा स्वीकृत हो गया। प्रतिवादी के आवेदन पत्र दिनांक 73 के अनुसार पुनः संस्थापन किया गया। बदर का प्रमाण पर्याप्त रूप से स्पष्ट नहीं था। प्रतिवादी ने लातूरा हो से ही क्रय किया था, जिसका स्वामित्व मानदो 1944 में ही टाइटल अपील नंबर दावा अस्वीकृत। So therefore the ultimately the plaintiff's, the state's objection was ultimately rejected by this application.
So ultimately by this order, your possession since 1956 has been recognized.
Yes.
What is the consequence?
Consequence is that
Because here also वादी ने इतना तारीख को 1956 से
हाँ
रब किया,
हाँ हाँ
right?
So once it is recorded and it comes in any record that I am in illegal possession since 1956 also, and it is reduced into revenue records of the state, and state files an objection, and then also that, then it was for
ये
them
वाला जो
to
order है जो हमको पढ़ा नहीं रहा, आपके पास clear order है?
कौन सा है वो?
ये last वाला exhibit 5 पे last page.
अच्छा है यही एक सर्टिफाइड कॉपी
लिखा है। ये बदर का प्रमाण पर्याप्त नहीं करता, बदर का
बदर तो हुआ
What does that mean, बदर?
सर्वे
वो सर्वे।
These days, Your Lordship, there is a glossary which has been published by one Sunil Kumar Singh. I think that if Your Lordship would also have it.
एक बार मंगाइए किताब।
सुनील कुमार सिंह ने आया पीला रंग का किताब है। पूरा ग्लॉसरी ऑफ रेवेन्यू
Glossary of-
टर्म्स है उसमें अकॉर्डिंग टू मी वुड बी
ये जिसका स्वामित्व मांगो केस 5, 6, 7,
हाँ
ये क्या है 5, 6, 7? बट विगत 1944 से ही
This was a suit which here it is coming, but no such evidence has come. It was a suit by which my vendor who was a vendor in 1956, he had acquired title in 1944 in a separate suit that is being mentioned.
Okay, so his title was recognized in that Mango case.
Yes.
And he is your vendor.
Yes.
So therefore your possession with respect to the suit property since 1956 has been recognized.
Yes, because in previous phase your Lordship took note of that.
But that was ultimately recalled. But ultimately, what is the finding?
Finding is that state's objection has been rejected. And this is not in dispute that state's objection has been rejected. Both the courts have concurrently held this also. State's objection was rejected.
What was the objection? What was the nature of objection of the state?
This is one of the ground on which
What was the nature of objection? उनका title तो लिखा हुआ था अनाबाद बिहार सरकार, right? बिहार सरकार का title तो it was mentioned, and they only said that it was in illegal possession since 1971.
71, which was rectified to 1956.
Rectification का कोई direction नहीं है. State के objection पर rectification का order नहीं हो सकता, right? State के objection पर आपके favor में rectification का order नहीं हो सकता. नहीं होगा.
Because if I was noted to be in illegal possession, then I was required to have filed an application for correcting the record, taking note that I had title and therefore.
So they were objecting to the recording of the record of rights that you were in
Illegal possession.
since
So
1971
basically their objection was that I should not have been recorded to be in possession.
to be in possession at
To
all.
be in possession. So because that was recognizing me to be in possession, and the record of right was recognizing to me to be in.
And therefore the court ultimately held that not only you but your vendor was also in possession.
Yes.
Because there was a case
Yes.
with Mango Mills.
Yes.
So the date of possession became a dispute and your actual possession also was in dispute.
Yes. So, but it was there. Again, I'll be repeating that. But no, nothing further was done by the state.
So what do you want to derive out of this?
Yes. My contention is that, Your Lordship, first I had acquired, because ultimately when I came to know on the basis of such entry in the record of right, when I was sought to be dispossessed, then I filed a suit for declaration of my right title interest. So even then there are two things. First, that my title was there because I had the person who was title holder in 1956, he had transferred me by way of a registered deed of sale, and I was in possession of the same since 1956 onwards. So I said that I have title on the property, and the state's objection also was rejected. This is one. Second, let us assume that even if it is held that I did not have any title, then my second line of action contention, and it was there in the pleading also, that even if it is held that I did not have any title, because I was in possession of the property on the basis of a registered deed of sale executed in 1956, and since then I was in possession, which was recorded as illegal possession in 71, objection was filed, and that was also rejected. So consequence would be that now even if my title is not held or declared, then I have the title from 1956, 30 years if it is gone. No suit for recovery of possession was ever filed. So once I was recognized, 30 years they were required to. 30 years, why I am saying? Because it was a property belonging to the respondent state. They were claiming the right of it. Till date, no such suit was filed. Normally it would have been 12 years, but for state's government it was.
What is the date of entry in record of right?
Yes, that has been taken.
Date is 1979.
Yes. 79 it is finally published,
Yes.
but they had already filed their objection on 6/7/1973.
So this is at the stage of not final publication.
The draft publication.
It was at the stage of draft publication.
Yes. But ultimately, rejecting their contention, finally it was published.
What was the entry in the draft publication?
Entry that I am in illegal possession, and
Since
Bihar
1970.
Sarkar was noted.
Since 1970.
Yes,
So in the 19, when was the suit filed?
suit was filed in 19. 2006. And with regard to filing of the suit, I had stated
So your knowledge about the wrong entry is not in doubt.
although I have stated, I must be clear, it has come in Exhibit 5 that I had appeared and I have filed an objection also. And based on that, the state's claim was rejected. But here I have said that for the first time I came to know, in my suit I have said, let us assume that that particular statement of mine is incorrect.
What is the final date of this particular order? When was it finally passed?
It was
73, is it?
73.
So you say that you had no idea about the final publication in 1970.
Yes, that I have said. Yes. I stand corrected.
It is not your
Yes.
case, you have no idea.
Yeah, no.
You were not aware about the final
Final
publication in
publication.
1979
Yes.
because nobody had taken any steps personally to get you evicted.
Yes. So,
So your limitation for the suit is in terms of their saying,
yes,
not
that
commence
is-
from 1979, but only since you were already in possession, it will commence from the actual cause of action.
yes.
When they disturb you or otherwise.
Yes.
What was the cause of action disclosed?
Yes, I have mentioned that in your Lordship may kindly turn to internal page 2 of the trial court judgment, para 2.1. After 4 lines, I've said. Para 2.1 I am reading. It is further stated that the aforesaid possession of the plaintiff and her mother, Masjid
Forest
Ali.
Department. Right.
Yes, 2005 one officer came and then he asked me to vacate and threatened the plaintiff to dispossess her from the suit property on the basis of wrong and erroneous entry in the record of right, finally published on 10
Let us see the finding of the learned trial court in connection with your with the points of substantial questions
Yes.
of law which are important. There are concurrent findings.
I had already read 6.3,
Yes, yes.
page 7, and then your Lordship may directly skip to internal page 9, para 9.
Yes. After hearing.
Yes. After hearing the argument of both parties and after going through the entire pleadings of the parties and also analyzing the entire oral and documentary evidences adduced on behalf of the plaintiff, I find that it is admitted fact of this case, the suit land which is khata number 907, plot number 2988 and area of so and so and plot number so and so, measuring an area of so and so of ward number 9. Notified Area Committee, Jamshedpur is recorded in the record of right published on 1979 in the name of one Bihar Sarkar, and the mother of the plaintiff has been shown in illegal possession since 1971, Exhibit 7. Identity of the suit land is also admitted fact of this case. It is the exclusive case of the plaintiff that mother of the plaintiff, Masjid Ali Tirki, had purchased the suit property from Dodra Ho so and so, Jamshedpur district so and so by virtue of registered sale deed number so and so dated 6/8/1956, and since then the mother of the plaintiff and her family started residing by constructing house thereon without any interference or any objection from any corner. After the death of her mother, plaintiff being the daughter inherited the suit property and has been coming in possession of the same without any obstruction from any corner. It is further case of the plaintiff that while she was in possession over the suit property on 15/4/2005, one person claiming to be staff of Forest Department threatened her to dispossess her from the suit property on the basis of wrong and erroneous entry in record of right, annually published on so and so. So after approximately 10 lines, if you will skip, or I'll read entire, whatever.
You read it.
I'll continue.
Yes.
Thereafter, plaintiff searched and inspected the record of rights in respect of the suit property and proved no that the suit property is wrongly recorded in the name of one Bihar Sarkar, and her mother had been shown in illegal possession since 1971 in remarks column. I find that the plaintiff has nowhere mentioned either in her plaint or her evidence that which date she searched and inspected the record of right in respect of the suit property in the office record room regarding the wrong entry in the name of one Bihar Sarkar in record of right. I further find that in view of the aforesaid fact, plaintiff is claiming a right title over the suit property on the basis of sale deed, Exhibit 1. On perusal of Exhibit 1, it appears that the vendor Radura who has acquired the land from ex-landlord on the basis of rural settlement, but vendor has not disclosed the name of ex-landlord in the aforesaid sale deed, Exhibit 1. Furthermore, plaintiff has also not mentioned this fact in her pleading, nor has adduced any oral or documentary evidence on it. It further appears that Lotra, who belongs to scheduled tribe, and Wendy, mother of plaintiff, belongs to Christian community. There is nowhere mentioned in the recital of the sale deed, Exhibit 1, that vendor Lotra Ho has sold the suit land after taking permission from Deputy Commissioner. The plaintiff has not mentioned this fact in her plaint and also not adduced any evidence on it. There is no any documentary evidence which could establish that the suit land was sold in favor of the mother of the plaintiff after taking permission from DC. Section 46 of CNT Act describes restrictions on their right by a Rayat. Section 46 reads as follows. Then your Lordship may skip that section 46. Thus it is clear that vendor Lodra who has not sold the land in favor of mother of plaintiff after taking prior permission of the Deputy Commissioner, and as land has been sold without previous sanction of the Deputy Commissioner. So sale deed exhibit 1 executed by Lodua Ho in favor of mother of plaintiff becomes void ab initio, and title of the land cannot pass to the mother of the plaintiff through so-called sale deed exhibit 1. Moreover, plaintiff has not filed any sheet of paper regarding the suit land which could establish the peaceful possession of the plaintiff over the suit land. I find that neither Malgujari receipt with respect to the vendor nor any government rent receipt, mutation slip belonging to the plaintiff with respect to the suit land has been filed by the plaintiff. On the other hand, PW1 plaintiff herself admitted in a cross-examination of para 25 that the suit property has been recorded in the name of state government in the record of rights of 1964. Further stated that again suit land is recorded in the name of Ban Bihar Sarkar in the record of rights of 1977. Plaintiff could have made application to CODC for realizing the rent with respect to the suit land, but I find that plaintiff did not do so. Rather, she admitted in para 30 and that she never gave an application to CODC for realizing rent with respect to the suit land. Exhibit 5 is the order in objection case number so and so 7273. It goes to show that the state of Bihar had filed an objection case against the mother of the plaintiff under section 83 of CNT Act, in which the claim of the state was ultimately dismissed. But it does not clear from the order as to what was the claim of the state and what order was passed in favor of the plaintiff. Can I pause here?
Yes.
Now here, it was for the state because state had filed an application, so state ought to have come up with the actual objection that this was my claim. So that because of non-filing of that, what was the claim before the state, I could not have been non-suited. Although the plaintiff stated in para 9 of the pleading that in the case of a settlement officer has confirmed the possession of the plaintiff with respect to the suit land, but on perusal of exhibit 5, I find that it is not clear from that the possession of the plaintiff with respect to the suit land has been confirmed. On the other hand, this court finds that RS operation, the suit land has been recorded in the name of Ban Bihar Sarkar in the year 1979, and also so Ban Bihar Sarkar becomes the paramount owner of the suit land. It is settled principle of law that entries in record of right shall be presumed to be correct unless proved to be incorrect. The plaintiff has failed to bring any substantive material in record to rebut the aforesaid legal presumption. Furthermore, section 2 of section 84 CNT Act clearly says that the state government may by notification declare with regard to any specified area that a record of right has been providently published for each village, included in a village, and such notification shall be conclusive evidence of the publication. If the plaintiff had any objection regarding wrong entry in the record of right published in 1979, she should have filed a petition under 83, 86, 89 and 90 of the CNT Act for correction of the wrong entry in the record of right, but plaintiff did not do so in this case. Exhibit 6 to 6C are some holding receipts issued from Notified Area Committee Malgo with respect to holding number 71, which goes to show that these rent receipts bear the name of mother of plaintiff. But in my view, mere issuance of rent receipt by Notified Area Committee Malgo do not confer any title to the plaintiff with respect to the suit property. Thus, in view of the above discussion, I find that the plaintiff cannot claim his right over title over the suit land on the basis of sale-deed exhibit 1. Further case of the plaintiff is that plaintiff and her mother came in possession of the suit land on the basis of sale-deed exhibit 1 since 8/8/1956. That is, since more than 48 years without any interference from any corner, and thereby the plaintiff has acquired her indefeasing title and interest thereon by virtue of adverse possession well within the knowledge of all concerned. In the present case, I find that the plaintiff is claiming a right, title and interest over the suit property on the basis of sale-deed exhibit 1 and also on the basis of adverse possession. It is settled principle of law that no one can claim right, title and interest on any land on the basis of sale-deed as well as on the basis of adverse possession simultaneously, because the two means are contradictory to each other. Now,
You see, all the ingredients of adverse possession has been discussed.
yes.
So you do not the question of law that it has been framed is that it can be used only as a shield and not as a sword is not the correct question of law. How does? Because every ingredient of adverse possession has been discussed by the learned man.
But it does not say anything. But what it
No,
says,
it says that your adverse possession is not true. Neither there is foundation.
no,
pleading
why
to
it
that
is
effect,
not true?
nor there is evidence to that.
Yes, why it is not true? First, this finding your
No,
lordship
we
may
will,
con-
we will see the substantial question of law, right? Substantial question of law is that whether the first appellate court has committed gross illegality by observing that the plea of adverse possession can be used only as a shield and not as a sword in view of the principles laid down by the remedial court. So that is not the case here.
No,
The trial court does not say.
trial court, but the appellate court rejects only on the ground that I could have used it only as a shield and
We'll
not
see
as
that. We will see that. Is that the only ground or there are other grounds also?
according to me that was the
So far as trial court is concerned, trial court has passed a detailed order rejecting your claim of adverse possession.
But what is the ground?
The trial court did not say. And what is the ground is not the subject matter of consideration in the second appeal. Whether it could have been rejected solely on the ground that it cannot be used as a sword is the question of law.
Yes, that is there, but trial court and now trial court says that I could not have claimed my title on the basis of sale deed as well as on the basis of adverse possession.
Apart from there are other reasons. What
Yes.
do you say to this?
Yes.
Can you have this conflicting?
Yes, yes.
And in the claim, do you recognize that state is the true owner of the property?
Because
Because that is also
directly,
another ground it has.
this is one of this would always come when a person who is claiming his right on the basis of title also and on the basis of alternative plea of adverse possession, whether this can be taken on. This is one judgment, landmark judgment your lordship may kindly take note of, is otherwise there are other judgments, but this clarifies the entire issue. In what cases people can take alternative plea and it is not contradictory. May I read the relevant portion only of your lordship? Para 17.
Yes.
The legal possession there is no doubt well settled to establish a claim of title by prescription, that is adverse possession for 12 years or more. The possession of the claimant must be physical, actual, exclusive, open, interrupted, notorious to the hostile to the true owner for a period exceeding 12 years. It is also well settled that long and continuous possession by itself would not constitute adverse possession if it was either permissive possession or possession without animus provendi. Pleas based on title and adverse possession are mutually inconsistent, and the latter does not begin to operate unless the former is renounced. Unless the person possessing the property has requisite animus to possess the property hostile to the title of the true owner, the period of prescription will not commence. We are, however, of the view that the Gestian report in the Mohalla relied on by the plaintiff is inapplicable as much as the defendant had pleaded that he was in possession, having obtained possession in part performance of the sale agreement, as the defendant therein admitted that he came in possession lawfully under an agreement of sale and continued to remain in such possession, there was no adverse possession. This case is different. Here, main finding is there. This case is different as the defendant did not contend that he entered in possession under or through the plaintiff. His case was that he was in possession as a tenant under Gauramma from 1962 and he became the owner by purchasing the plot from Gauramma in 1985. He alternatively claimed that if Gauramma did not have title and consequently his claim based on title was rejected, then having regard to the fact that he had been in possession by setting up title in Gauramma and latter in himself, his possession was hostile to the true owner, and if he was able to make out a case of such hostile possession, and if he was able to make out a case of such hostile possession continued for more than 12 years, then he could claim to have perfected his title by adverse possession. There is considerable force in the contention of the defendant provided he is able to establish adverse possession for more than 12 years. When a person is in possession, asserting to be true owner, even if he fails to establish his title, his possession would still be adverse to the true owner. Therefore, the two pleas put forth by the defendant in this case are not inconsistent pleas, but are alternative pleas available on the same fact. Therefore, the contention of the plaintiff that plea of adverse possession is not available to defendant is rejected. So here was exactly identical case in
Not
there.
identical.
I say why absolutely identical.
You never gave up your plea of title. You never gave up your plea of title.
But here also same thing is there.
No, here he was claiming the title on the basis of some agreement. In this case, or maybe in the case of Mohan.
No. It was on the basis of an agreement. It was said that one Gauramma was there.
Yes.
I had entered into an agreement, but subsequently she sold me the property. So Gauramma, the person, the plaintiff in that case he was claiming against the Gauramma and the
He was claiming against Gauramma and consequently against the
the purchaser also.
purchaser.
Here,
And the title of Gauramma was held to be illegal.
therefore, in our case also, if this is applied, I am not claiming through state. If I claim through state and then I subsequently say that no, I have adverse possession also, then the matter would be different. Here is a case that I am claiming my title through a person who is not claiming through state, absolutely independent person, and I say that he had title and he transferred the property to me, and my contest is against a third party, exactly identical in that case also. So they were not, and if I claim through the same person, and then I cannot claim adverse possession against the same person, that would be a different case.
No, but the law as pronounced in paragraph 17 does not say that you have to necessarily claim through the same person in order to claim adverse possession. That does not say. The principle of law which has been enunciated in para 17 does not say that the plea of adverse possession and title will be conflicting only when you are claiming through the same person.
Because it is said that
You
they are
can have a sale deed executed by a third person, right? And then you are claiming title over it. But at the same time, when you claim the title, you are straightaway claiming title. And then at the same time, you claim that as so far as state is concerned, there is adverse possession.
yes. Therefore, your Lordship, para 18 clarifies that. Para 18, if your Lordship would see it, that this is the only judgment which actually clarifies the entire. Otherwise, there are other judgments which obviously this particular aspect has not been taken. This is an aspect where it says very clearly that if I am claiming through some other person and I am claiming my title and ultimately I fail in establishing the title of the person through whom I am claiming, then I can claim my adverse possession against a third party who also. This is what. Your Lordship will only allow me to place this once again. This particular paragraph, if
Para
Your
18,
Lordship,
repeat it.
para 18, if Your Lordship will
Yes,
only allow me. We are, however, because it is discussing the previous law which is mentioned in para 17. Why para 17 would not be applicable in the instant case? And this is being clarified by the Honorable Court. We are, however, of the view that the decision of Mohanlal relied on by the plaintiff is inapplicable as the defendant therein had pleaded that he was in possession, having obtained possession in part performance of the sale agreement. In Mohanlal, this was the case. He had obtained possession in part performance of the sale agreement, as the defendant therein had admitted that he came into possession lawfully under an agreement of sale and continued to remain in such possession, there was no adverse possession. This is the case law of the Mohanlal. This is being discussed. But now this case is different. as the defendant did not contend that he entered in possession under or through the plaintiff. His case was that he was in possession as a tenant under Goramma from 1962 and he became owner by purchasing the plot from Goramma in 1985. He alternatively contended that if Goramma did not have title and consequently his claim based on title was rejected, then having regard to the fact that he had been in possession by setting up a title in Goramma and later on himself, his possession was hostile to the true owner. And if he was able to make out a case, make out such hostile possession continued for more than 12 years, he could claim to have perfected his title by adverse possession. There is considerable force in the contention of the defendant, provided he is able to establish adverse possession for more than 12 years. When a person, this is the issue, when a person is in possession asserting to be the owner, even if he fails to establish his title, his possession would still be adverse to the true owner. Therefore, the two pleas put forth by defendant in this case are not inconsistent pleas but alternative pleas available on the same fact. Therefore, the contention of the plaintiff that the plea of adverse possession is not available to the defendant is rejected. So here also exactly what I am saying, that applying this ratio, that when a person is in possession, I am in possession, asserting to be the true owner, and if I fail to establish my title, then my possession would still be adverse to the true owner, that is state. If it is ultimately held that I didn't fail to establish it. So this case cannot be equated with other cases where the trial court says that the two pleas are alternative to each other, contradictory to each other, not alternative.
You are saying it has been found to be illegal on the ground of violation of section 46.
Yes.
Was there any plea set up by the state to that effect?
No. With regard to section 46, there was no such plea. General, what was there, it is mentioned. It was only a general plea that the suit was barred by CMT BLR Act specifically. And therefore, this issue was framed by.
They did not even need any.
No. Therefore, this issue number 3 was there, that whether the suit is barred by limitation, waiver, estoppel, acquiescence, and under the provisions, absolutely general. So I never had this opportunity to show or to put forth whether there was a permission or not, whether permission was actually required or not. There would have been a case, there can be a case that because it is only applies to a Rayati land.
Then under such circumstances, when the land is recorded in the name of Bihar Sarkar, right, but the title is claimed by Bihar Sarkar, where is the question of violation of section 46?
Yes. That I stand.
If they
Yes.
claim title upon themselves, that is their specific case,
Yes.
that the land belongs to them. So where is the question of section 46?
Yes.
It was never the case that it actually belonged to them.
Yes,
So
and this.
and then it was transferred, but the transfer was against the provision of section 46. It was not their case.
Yes. I
So, in order to transfer the case from Bihar Sarkar to you, right, there was no occasion to have any permission.
Yes, no permission. And one more.
You see, there are two ways. One is there is an original landlord. By virtue of vesting, the property vests with the state. This is one aspect of it. Second is the land belongs to one raiyer, and he is otherwise entitled to the property. He belongs to a scheduled caste or scheduled tribe community, and in order to transfer the land, he has to take due permission. But that is not the case of the state.
Not, it is not the case. Your Lordship, one more thing. Because Your
And
Lordship,
he, anyways, okay, let us see. These facts are required to be specifically admitted.
this was required to be.
And
Because-
special power is vested with the state deputy commissioner to annul such transfers. they have special powers.
Yes,
under
power
the
is there
CNT
in,
Act, Section
in 49 that power is there.
71.
49 is there, but that would apply only in cases where permission under section 49 has been taken and the property has been transferred. Then that transfer can be annulled under 49(5). That is there. But here would
In
have been
absence
case
of permission also it can be
71A.
annulled. 71A is there?
Absolutely. Any violation transferred by violating the provisions of 46A, then 71A would
Then
have.
71A, there are also, and here is a case where the original person who has transferred the property is not claiming.
Not claiming, and
He is not
as your
claiming, he has
lordship,
not come.
as your lordship pointed out, then what would happen under section 71A? The property would be restored back to the original
Yes, to the
person.
original, he is not there before the court.
It will not.
Even if the sale deed is held to be violative of the provision of CNT Act, then what is the consequence? The
Well,
property
they
will go to him,
Go to the,
not to the state.
Yes, no.
By any stretch of imagination, it will not go to the
No,
state.
it would not. It would not.
And there is no finding that otherwise the registered deed is null and void.
No,
There is no other reason given.
no, sir.
That's it. So you want to say that the point of limitation will be counted from the date of cause of action, and then you want to say that this finding of 646 or whatever. Let us see each one of them. Appellate court.
Apple. First, trial court, your lordship, it has discussed, as your lordship pointed out, para 10.1, that it has discussed and it has said that it was not open, not hostile. All these findings are erroneous in view of the fact that my illegal possession is being recorded in the record of right, and if that is being objected by the state. It is already objected by the state, so my possession as illegal possession is being recorded.
Yes, it is.
Therefore, there could not have been any better hostile
30 years.
document than.
30 years elapsed from 1956.
Yes.
Did it elapse from 1971?
Even otherwise, because state did not
71.
file. State did not file. If state would file a suit against me, and then it would say that the provision of section or article 65 would come. State never claimed, although I am in possession, undisputably, record of right records my possession. State does not file any suit. And from 71, 30 years lapses in 2001 and 2006, I filed a suit.
Claiming at
No,
least.
and that too I have filed a suit, not case.
Let's see the appellate court's order.
It framed 4 questions of point for determination. It is there in running page 45. Whether the plaintiff appellant has right, title and interest over the suit land, whether the plaintiff has perfected his right title by way of adverse possession, whether the suit is barred by law of limitation, whether the plaintiff is entitled to get the relief prayed for in the suit. Point number 1. Then your lordship, relevant finding, can I only place that?
Yes, we can listen.
Running page 47, after 5 lines from the top. The case of the plaintiff, after 5 lines from
Yes.
page 47. The case of the plaintiff is that the land earlier belonged to Laduraho, but sale deed of 1956 shows that Laduraho got the land about 30 years ago from the then landlord by oral settlement, and they cultivated the land. It is not in dispute that settlement of land can be brought through oral, but there should be a subsequent payment of rent and evidence of cultivation on the basis of illegal possession on the government land. Even for long, nobody can be owner of the property. After passing of the BLR Act, so and so, all forest land vested in the government, therefore, government became the owner of the property. It appears from the record that in 1978, the suit land was recorded in the name of Bihar Sarkar, and the plaintiff has not challenged the entry within 12 years. Then it discusses para 46, section 46 of CNTF. It quotes section 46.
No, you just further plaintiff has not
Yeah.
disclosed.
Further, the plaintiff has not disclosed the name of the ex-landlord who settled the land in favor of Ladurado. In this regard, pleading of the plaintiff is also silent. That who was the ex-landlord? In her examination in chief, she supported her pleading. In the plain pertaining cross-examination, paragraph 25, she admitted that previously the land belonged to landlord Gobar Mukhi of West Bengal. Further, she admitted that after the abolition of Jamindari, the land vested in government of Bihar. In paragraph 30, she admitted that she has not filed any application for fixation of rent. Thus, the evidence of the plaintiff itself shows that after vesting of the estate, the suit land vested in the government of Bihar. Further, the record goes to show that the Ladura Ho belongs to scheduled tribe and the mother of the plaintiff is Christian. And under the provisions of CNT Act, permission of the Deputy Commissioner is required for transfer of land belonging to scheduled tribe, and no title passed in favor of purchaser unless the permission is obtained. Under section 46 of CNT Act, complete restriction, 46 he says, and then he mentioned that no transfer in contravention, that bold portion is there in page 48. No transfer in contravention of subsection 1 shall be registered in any court recognized as valid in any court, whether in exercise of so and so or revenue jurisdiction. Thus, on the basis of alleged sale, title cannot be passed in favor of mother of plaintiff. No malguzari receipt or government receipt concerning mutation of the suit land filed by plaintiff to support her possession. Further, since the suit land is in RS operation, is recorded in the name of Ban Bihar Sarkar. Therefore, Ban Bihar Sarkar is the owner of the suit land. In law, the presumption of correctness of entry in the record of right is made unless and until it is proved to be incorrect. Now, last 3 lines can I read? Thus, on the basis of evidence on record, I am of the considered view that the plaintiff have not been able to establish a right title interest on the suit land on the basis of sale deed. The court below, after going through the oral and documentary evidence available on record, rightly gives finding as the right title in interest of the plaintiff. Thus, this crucial point is answered against the plaintiff and in favor of the defendant. Point number 2. This is adverse possession. As regards plea of adverse possession, it is settled plea that adverse possession is not purely a question of law, but blended one of fact and law. And the person who claimed adverse possession have to prove that on what date he came in possession, what was the nature of possession, whether it was known to the owner of the property. In this case, though the plaintiff has claimed the land on the basis of adverse possession too, but the plaintiff has totally failed to prove through pleading or in other evidence before the court that from which date her mother came in possession and from which date her possession became adverse to the state. It is settled law that in the eye of law an owner would be deemed to be in possession of the property so long as there is no intrusion and none used to be the property by the owner, even long would not affect his title. Further, at one time, plaintiff can claim her right on the basis of purchase from Ladura in 1956, but at the another instance, she has also claimed to be the owner of the property on the basis of adverse possession. Plaintiff himself is praying for declaration title on the basis of adverse possession, which presupposes that the title is with somebody else. Adverse possession presupposes the title of another person. So, the plea of basis of title as well as adverse possession is not maintainable at the same time. Further, plea of adverse possession can be used as a shield and not as a sword. Thus, the plaintiff has not been able to establish plea of adverse possession, and the court below has rightly decided the plea of adverse possession against the plaintiff. Point number 3. As regards law of limitation is concerned, it is observed that in the case of so and so, in the body of claim, the plaintiff has pleaded that the defendant was allowed to remain in possession in the so and so much before that case is being discussed. Admittedly, in the year 1966, the revisional survey record of right was finally published, and the name of defendant is in respect of the suit plot. The instant suit has been filed in 1984 after 18 years of the final publication of record of right. In view of these admitted facts, it can be said that there is no period of limitation for filing the suit, and that the entries in the record of right is long or declaration of title and recovery of possession. Then your Lordship may kindly skip all the other paragraphs. Second last paragraph of the page 50. In this case, the record of right finally prepared and published in the year 1979, and in the record of right, the suit land was recorded in the name of one Bihar Sarkar. No rent of the suit land has been assessed. No mutation ever allowed on the basis of alleged purchase of the land by the plaintiff's mother. At the relevant time, publication of record of right, the plaintiff were found to be in illegal possession of the suit land. The plaintiff is an encroacher of the suit land. The entry in the record of right has not been challenged by the plaintiff or her mother within a period 12 years from its publication. The plaintiff has filed a suit in 2006, that is after the period of limitation. According to the point of limitation is also answered against the plaintiff and in favor of the
You see, you have the JD in your paper, 1956. What is the proof of possession? Because possession is different from title.
Yes.
You might acquire title by virtue of 1956, even if it is disbelieved for a moment, it is assumed, or even if it is believed. Then under such circumstances, that will not prove your possession. So no document has been produced from your end to show possession since 1956. There is nothing.
No, let us remove all the documents.
Yes.
Then also, when the survey is being conducted, what better document would I have than the record of right itself, which records that I am in possession, though illegal.
They record your possession since 1971 only. They recognize it only from 1970.
But your Lordship took note of that exhibit 5 where it says that it is from 1956. It says that it is from 1956. Even assuming that 1971 also, I am in, that is the recognition of my possession, and that is being objected by the state. I say that I cannot have a better document of possession than the record of right itself.
And there is a presumption to that effect.
Yes. And they object to that. If they would not have objected, the matter would have been different. They object, therefore they are aware of my possession.
And they never
Your
filed
Lordship,
any suit to evict you.
let us assume there is no Malgojari rent receipt issued by circuit officer.
So your
When-
possession, it cannot be said that you were in possession since 1956. At least.
Because
To that extent.
why I say that I am in possession from 1956, there is a registered deed, then followed in 1971, I am found to be in possession, which the settlement officer takes note of the fact that I am in possession from 1956.
That order was recalled, the court records that this particular document is not very clear with regard to your.
So this order was against whom? This order was against the state. So state was required to clarify. This order is in my favor. Ultimately, my possession has been recorded and objection of the state. Concurrently, both the courts come to the conclusion that the state's objection, I was recorded in illegal possession, state's objection with regard to illegal possession has been rejected. So these are also findings of fact, coupled with the Exhibit 5 itself.
Rather, प्रतिवादी ने लड़का हो से नहीं, वदर का प्रमाण पर्याप्त रूप से स्पष्ट नहीं. It means what? It means that there was no basis to record your possession since 1971. वदर का प्रमाण पर्याप्त रूप से स्पष्ट नहीं. What does that mean? ये लास्ट में आपको देख लिया
Your Lordship may take internal page 3 where it says that अतः वादी का दावा साबित के आधार पर मान्य ठहरता है. Then he takes note, दावा स्वीकृत, खाता नंबर सो एंड सो, खाता से विलोपित कर इतना इतना अंकित करें और मसीह धानी तिर्की सन 1956 लिखे. अवैध दखल मसीह धानी तिर्की 1956. That means the whatever was the objection, ultimately my objection, अवैध दखल, illegal possession was recorded since 1956. And then what he says in the next page,
ये ऊपर क्या लिखा है पुनः स्थापन के लिए आवेदन सुना दावा स्वीकृत 14/8/73
your Lordship is reading
the third page. See 14/8/73 पुनः स्थापन के लिए आवेदन सुना दावा स्वीकृत. तो इसका मतलब रेस्टोर हो गया 14/8/73.
हाँ restoration के लिए होगा.
ठीक है और 14/8/73 के बाद नेक्स्ट ऑर्डर का 14/8/73 का ही ऑर्डर.
हाँ वो देख रहे हैं. क्योंकि उससे पहले है 8/8/1973 उसमें नोटिस का मिला घर पर कोई नहीं है, नोटिस लटका कर जारी करने का सोचो, दावा स्वीकृत एक लाइन है. देन पुनः संस्थापन के लिए आवेदन सुना,
दावा स्वीकृत किया गया ना.
हाँ उससे पहले
स्टेट का दावा स्वीकृत किया.
हाँ
राइट.
हाँ
उसके
लेकिन
बाद
वो-
क्या हुआ रेस्टोर हुआ एट
हाँ.
योर इंस्टेंस.
पहला रेस्टोरेशन लगता है
हाँ एट योर इंस्टेंस
24/8/1973
एट योर इंस्टेंस.
अस्वीकृत. देन प्रतिवादी के अनुपस्थिति के कारण दावा का एक पक्षीय निर्धारित बदर नंबर सो एंड सो आदेश से खाता बनाया गया है. प्रमाण 1956 का केवाला प्रस्तुत किया गया था. गैर मजरूआ जमीन का उनका बंदोबस्ती बिना कुछ है अस्पष्ट है. बंदोबस्ती के प्रमाण का उल्लेख कहीं नहीं है. अतः वादी का दावा स्वाभाविक के आधार पर मान्य ठहरता है. Therefore, this was actually reasoned order which was passed in favor of the state. Then it is said that दावा स्वीकृत.
ये जब दावा स्वीकृत हो गया तो ये रेस्टोरेशन तो रिजेक्ट हो गया. दावा अस्वीकृत. पुनः स्थापन के लिए आवेदन सुना दावा अस्वीकृत.
Eight 873 is not clear as to because that mentioned that वादी पक्ष से प्रतिवादी का पता मांगा गया था लेकिन नहीं दे सके तभी पुनः नोटिस दिया गया था. लेकिन तामील नहीं हुआ है. नोटिस तामील जब राशि का उल्लेख है कि घर पर कोई नहीं है, नोटिस लटका कर जारी करने का दावा स्वीकृत. But ultimately, Your Lordship, it is the case of both the parties and concurrent finding of the court that my illegal possession was recorded and it was ultimately the state's objection with regard to that was rejected. Yes, now Your Lordship, I will clarify. Your Lordship may read the concluding portion of page 4.
Yes.
Here everything would be clear. प्रतिवादी की अनुपस्थिति में दिनांक 8/8/73, नाउ योर लॉर्डशिप में सी 8/8/73 को एक पक्षीय विचारण कर निर्णय दिया गया था. That means it was allowed ex parte, जिसके फलस्वरूप वादी का दावा स्वीकृत हो गया था. प्रतिवादी के आवेदन पत्र दिनांक 16/8/73 के अनुसार पुनः संस्थापन किया गया. It was restored. Then बदर का प्रमाण पर्याप्त रूप से स्पष्ट नहीं था. प्रतिवादी ने लादुरा हो से क्रय किया, जिसका स्वामित्व मांगो केस नंबर 567 पर विगत 1944 में ही टाइटल अपील नंबर सो में मान्य ठहराया गया है. नाउ दावा अस्वीकृत, पूर्व आदेश विलोपित. That means the order which was passed on 8/8/1973 allowing the objection of the state, that was set aside, and the ultimate objection was of the state was rejected.
अब ये जो थर्ड पेज में जो बॉटम में ऑर्डर है वो क्या?
वो है, वो सिर्फ लिख रहे हैं कि अभ्यर्थी हम समझ
प्रतिवादी के अनुपस्थिति के कारण दावा एक पक्षीय निर्धारित बदल इतना आदेश से खाता बनाया गया है. प्रमाण से 1956 का केवाला प्रस्तुत किया गया. गैर मुजर्बा जमीन बंदोबस्ती बिना अस्पष्ट बंदोबस्ती के किसी प्रमाण का उल्लेख नहीं है. अतः वादी का दावा के आधार पर मान्य है. दावा स्वीकृत. उसके बाद वर्तमान खाता से विलोपित कर खाता में अंकित करें तथा मसीह धनी टिर्की का 1956 में. ये ऑर्डर कब का है और कहाँ से आया?
ये समझ में नहीं आ रहा, because this was an unreasoned order 8/8/73.
It appears you had also filed an application for rectification.
For
Rectification of the Court of Right.
no, we had filed, because this would be clear from the last portion of the concluding paragraph of the 24/8/1973.
24/8 नहीं है, 14 है ना, हिंदी में लिखा. ये 14/8/73.
Because it's actually confusing. Now your lordship may see order number 5. Order number 5 is at page 3.
Yes.
पुनः संस्थापन के लिए आवेदन सुना, दावा अस्वीकृत.
Yes.
This actually is concluding portion of the previous last page. That means page number 4, concluding portion, that is also order dated 24/8/1973.
14/8. 14/8. This 14/8.
नहीं 24 है.
24.
हाँ दोनों 24 है.
अच्छा ठीक है.
दोनों 24/8/1973 है.
ठीक है.
ये जो concluding portion है और जो order number 5 है. And therefore the actual order is 8/8/1973. This is the portion of that order. That means page 3, last portion, whichever is there, that reasoning dawa swikrit is a portion of. Reasoning is there in page 3. Reasoning of order dated 8/8/1973. I don't want to get an order, Your Lordship, it would be at least record. I'll only pray that Your Lordship, because it can be produced by the state, the original record.
Will not ask them anything.
But
Whatever
otherwise, according to me, absolutely concurrent finding of both the courts that the state had objected to such entry and that was rejected. And they have not brought anything else to disprove this.
Exhibit 5 has been excluded is the substantial question of law number 3. This is exhibit 5 we are reading.
Yes.
Substantial question of law number 3.
Yes. Whether the first appellate court has committed perversity by excluding exhibit 5 is relevant material in arriving.
Yes.
And actually he has not considered it. The effect of that document. The appellate court, in concluding portion, page 50, it says that the record of right was finally prepared and published in the year 1975, and the record of right was recorded in the name of so and so. No rent of the suit land has been assessed, no mutation ever allowed on the basis of alleged purchase. Here it fails to take note of the exhibit 7.
Exhibit 7 is what?
Exhibit this notified area committee with the rent receipts with the notified area committee had given. That was there.
Notified area committee had given rent receipt when?
It has given in 76.
76. So your possession is recognized in 71. So that is irrelevant.
Yes.
That is absolutely irrelevant. And even if it is counted from 71, more than 30 years.
Yes.
And had they filed any suit, the suit would have.
Been barred by limit, but they have not filed.
They have not filed it, they will not file it.
Yes, because they could not have filed.
Yes, respondent.
The judgment of the trial court had made everything clear that entry was in the favor of 1 year of Sarkar. So it was onus on the plaintiff in this plaintiff's case to stand from one leg. But plaintiff has failed to bring any sheet of paper regarding his title and
Yes, he has proved it by filing a registered sale deed. What else is required?
It has been discussed in both the concluding portions of the judgment of lordship.
I hope your AT should see what you are asking.
I have gone through this.
इतना ही बस करना होगा?
It was up to the plaintiff to take action against the decision. Because entry was in the favor of City Bihar. So they should have moved taken the result of section 3
That is why they
90.
No, not necessarily. They can come and file a title suit. That is why they have filed a title
But
suit.
they have
What
come
else?
up, but they have come in 2006 lordship.
So
And they have failed to so that when they came
you tell us in the light of Daya Singh's judgment, when did they came to know about the final publication of record of right in the year 1970? When did they come to know about it?
It has come in the order lordship that they should have filed before, much before.
That is a substantial question of law. You answer. Merely because it has come in the order is not sufficient. Entry in record of rights does not give any cause of action. This is the judgment of Daya Singh. Unless a person is in possession, right? There is all the proceedings under section 83 had taken place prior to the final publication, right? So far as and this particular order under section 83 was almost always in their favor, right? Then how do they come to know so far as the final publication of record of rights is concerned? And what is the cause of action? A person is in possession record of right में what happens is that somebody else's name has been inserted. How will he come to know? You have not initiated any proceeding to evict them from the suit premises. BPLE, no. You have not filed a suit, that also you have not done. Correct? So therefore the limitation would commence from the cause of action, not from 1979. How will it commence from 1979?
Regarding this, that one judgment which is placed by my learned senior, that's 17 in Seoul, regarding that in page number 12 of the trial court order, there is judgment that is a judgment of 1995. Supreme Court says that what should be when it is adverse position is claimed against state, these points should be taken into consideration and concerning those which have not been passed in trial court. I think that is the
Trial court judgment is not the final court. The final court of fact is the appellate court's judgment. Right?
Let it be tomorrow, Your Lordship.
Rejected. Can't be tomorrow.
Because the exhibit 5 on which plaintiff is relying, Your Lordship, is a order of ASO.
So, it
So
has
on
no
basis of
value.
ASO, a title cannot be claimed, Your Lordship. The very basis cannot be said that on the order of ASO, title can be given to plaintiff. It is their case that failed to prove it.
कल आप तैयार होके आ जाइए. But you have to prepare your mouth. आपका ये जो फ्री स्टाइल चल रहा है ना, जमीन है, समझे ना?
Tomorrow I'll
आप तो थे ही नहीं, आपको तो क्या ही पता है? घूम फिर के कहीं से भी आते हैं. Your advocate general should see how the land of the state is being protected by the councils. Your counsel who is here, he has not read the brief. इसको कोई आइडिया नहीं है. इनको कोई आइडिया नहीं है कि किसका क्या. वो जब वो पढ़ रहे थे जितना देर उतना देर अपना इम्प्यून जजमेंट पढ़ रहे थे. सेकेंड अपील, फॉरेस्ट जब फॉरेस्ट का प्रॉपर्टी है, स्टेट का प्रॉपर्टी है, इफ यू कंडक्ट दीस केसेस इन दिस मैनर, आई एम वेरी सॉरी टू से द स्टेट इज एट पार. हमारे लिए स्टेट को कोई स्पेशल प्रिविलेज तो नहीं मिल सकता है.
स्पेशल प्रिविलेज किसी को नहीं है.
स्पेशल प्रिविलेज यहाँ किसी को नहीं है.
फोर सब्सटेंशियल क्वेश्चन सब लोग आ गए.
सो अभी क्या आप बहस करते हैं?
तो अभी तो नहीं करेंगे. हाँ नहीं, हम कल करेंगे क्योंकि हम आई एम नॉट रेडी विद दिस. इंटरनल कम्युनिकेशन है उसको हम नहीं बोलेंगे. हम लोग ट्रांसफर ब्रेक होता है थोड़ा.
Essay number 241 of 2018. For the learned counsel appearing on behalf of the applicant, on behalf of the parties. This appeal has been filed against the judgment dated 9th of February 2018, decree signed on 23/2/2018, bracket close, passed by learned District and Additional Sessions Judge Roman 10 Jamshedpur in Civil Appeal number 03 of 2017, whereby the learned First Appellate Court has dismissed the appeal preferred by the appellant. The trial court judgment has been passed. The trial court judgment is dated 2012-2016, within bracket decree signed on 3/1/2017, bracket close, passed by learned civil judge within bracket senior division, bracket close 1 at Jamshedpur in title suit number 11 of 2006, whereby the learned trial court had dismissed the suit of the plaintiff. The suit was filed for the following relief. The title suit का जो judgment है ना, उसमें first paragraph में ही पूरा relief quoted है. The following substantial questions of law were framed by this court by the order dated 30/1/2023. The learned counsel for the appellant, has placed the facts from the trial court judgment and has submitted that the plaintiff was claiming title by virtue of registered SEBI number 3518 dated 8/8/1956. Who claimed to have purchased the suit property from Ladura Ho and claimed to be in possession of the property. The property was purchased by Masih Dhani Tirki, the mother of the plaintiff. The learned counsel submits that prior to publication, final publication of record of rights, a proceeding was initiated. The records of rights were finally published on 10/8/1979, wherein the suit property was shown to be recorded in the name of Ban Bihar Sarkar. And in the remarks column, the same was shown to be in immediate possession of Masih Dhani Tirki, the mother of the plaintiff, since 1971. The learned counsel submits that prior to final publication of record of rights, the defendant state had filed a case under section 83 of the Tobacco Tenancy Act with respect to the suit property against Masih Dhani Tirki. And by order dated 24/8/1973, the settlement officer had confirmed the possession of the plaintiff and plaintiff's mother. The learned counsel submits that the plaintiff came to know about the finally published record of right, which was dated 10/8/1979, only when one officer of the Forest Department had threatened the plaintiff to dispossess the plaintiff from the suit property in the year 2005. And thereafter, the plaintiff obtained the records of the finally published record of right and filed the suit, seeking declaration of right title interest over the suit property, and also seeking a declaration that the settlement entry in respect of scheduled land of the plaintiff in the record of rights finally published on 10/8/1979, showing the khata in the name of Bihar Sarkar was wrong and erroneous. The learned counsel has submitted that since the plaintiff was in possession of the suit property, there was no occasion to claim recovery of possession. Rather, no alternative relief was also claimed seeking recovery of possession if the plaintiff is found dispossessed from the suit property. The learned counsel submits that mere entry in finally published record of rights on 10/8/1979 does not give the cause of action to the plaintiff to file the suit. Rather, the cause of action arose when the authority of respondent state threatened the plaintiff, and therefore the cause of action arose in the year 2005 only. The learned counsel has referred to the judgment passed by Honorable Supreme Court reported in bracket 2010 bracket close Supreme Court SCC Volume 2 SCC 194 Daya Singh versus Gurdev Singh, and has submitted that and has referred to paragraph 18 thereof. 18, na? To submit that on the Supreme Court held that the High Court in the judgment issued in the same case had fallen in grave error in holding that the suit was barred by time and ignored to appreciate that the rights of the appellants of the case to have the revenue records accrued first arose in 1990 when the appellants came to know about the wrong entry and the respondents failed to join the appellants in getting it corrected. The court has held that mere existence of a wrong entry in revenue records does not in law give a rise to a cause of action within the meaning of Article 58 of the Limitation Act. The learned counsel submits that in view of the aforesaid judgment, the point of limitation is to be counted not from 1979, that is the final date of publication of Record of Rights, that is the date of final publication of Record of Rights, but from the cause of action as disclosed in the date. He submits that the substantial question of law number 4 is fit to be answered in favor of the appellant and against the respondents. The learned counsel, by referring to the first substantial question of law, the learned counsel for the appellant has submitted that there was no foundation pleading that the transfer of property by the crew who in favor of the mother of the plaintiff was ये तो pleading है, was barred by section 46.
Section 46, it would be
Section 46 of the Chotanagpur Tenancy Act. The learned counsel has submitted that the state was claiming title over the property, and the question of violation, and if the suit was barred, if the transfer was barred by virtue of section 46 of Chotanagpur Tenancy Act, then the property would have reverted back to the original owner and not to the state. Since the state was claiming the property, recourse to section 46 of the Chotanagpur Tenancy Act was completely out of the frame of the suit, and therefore such findings that the findings recorded by the court without any foundation pleading that the case was barred on account of absence of permission under section 46 of Tobacco Tenancy Act is not in accordance with law. And such findings are perverse. Yeah. The Learned Counsel has submitted that the state cannot dispute that it was their specific claim that the property belongs to the state. And such entry in record of right was challenged by the plaintiff and not by the state. अपना टाइटल तो नहीं डिस्प्यूट कर रहे ना? आप समझ गए?
सूट तो प्लेंटिफ लाया है, हम तो लाया नहीं।
आप समझ गए क्या सबमिशन है इनका? आप नहीं थे इसलिए बता रहे। अगर 46 का वायलेशन है तो प्रॉपर्टी आपके पास जाएगा कि ओरिजिनल ओनर के पास जाएगा?
ठीक है, प्रॉपर्टी
समझ गए ना?
हाँ, लेकिन हमारा
46 का वायलेशन
बट देयर इज प्लीडिंग इज देयर।
We'll see that. इनका सबमिशन करना
हाँ, ठीक है।
इनका ये करना 46 का वायलेशन है
अरे इट विल गो टू द
ओरिजिनल ओनर नॉट टू द स्टेट, राइट? With respect to the second substantial
But this is
question
the
of
submission of the.
this is a submission. Of course, his submission says that you answered it properly tomorrow. And explaining it to you, his submission, which is not a part of my job at all. The Learned Counsel submits that the first substantial question of law is also fit to be answered in favor of the appellant, and as such findings are perverse. With respect to second substantial question of law, the Learned Counsel has submitted that has placed the trial court judgment as well as the first appellate court judgment, and has submitted that even if everything is taken into consideration, the Learned Counsel has submitted that the Learned Trial Court has considered the claim of adverse possession on various aspects of the matter, but the Learned First Appellate Court has rejected the same by referring to, by observing that the plea of adverse possession can be used only as a shield and not as a sword. And such observation of the Learned First Appellate Court is contrary to paragraph 64 of the judgment passed in the case of Ravindra Kaur Withdrawal, which the judgment has been cited while framing the second substantial question of law. The Learned Counsel has further submitted that the fact that even if everything is taken against the appellant, then also the entry in record of right showed that the plaintiff was in possession of the property since 1971, and the suit was filed
2006.
in the year 2006, which was beyond the period of 30 years. He submits that in view of this,
You're looking. And the state, and the plaintiff had filed a suit.
yes,
State had not filed any suit.
the plaintiff had filed a suit seeking declaration of right title interest over the property, and the state neither took any action to evict the plaintiff, nor took any action, nor disturbed the possession of the plaintiff in any manner, although it was in full care of the state that the plaintiff was in possession of the property since 1971. In such circumstances, the plaintiff had perfected the title by way of adverse possession, since their possession was undisputed, open and hostile to the title of the state for more than 30 years. He submits that. कौन सा article होगा?
65.
This would be in view of the provisions of section Article 65 of the Limitation Act.
Your Lordship, substantial question of 2 and 3 would be actually one and the same. I mean, the effect of Exhibit 5 would be adverse possession.
Okay. 2 and 3 को एक साथ रखेंगे. While referring to the third substantial question of law, the Learned Counsel submits that the state made an attempt to get the entry in record of right which was in favor of the plaintiff to the extent that the plaintiff was in possession of the property since 1971, but that plea was rejected by Exhibit 5. Meaning thereby, he also submits that since such a plea was rejected, the entry in record of rights continued to be of that, continued to show that the plaintiff was in possession of the suit property since, at least since 1971.
Yes.
He submits that even Exhibit 5 clearly shows that that there was a contest with regard to the possession of the plaintiff shown in the record of rights since 1971, and taking Exhibit 5 into consideration, the undisputed fact which comes up from the records of the cases that the plaintiff remained in possession of the property at least since 1971, and therefore there can be no doubt that the plaintiff had perfected the title by way of adverse possession, being in possession for more than 30 years, and the basic ingredients of adverse possession were otherwise duly satisfied. Okay?
Yes.
Limitation हो गया, चौथा नंबर हो गया सब खत्म.
हाँ.
The learned counsel has relied upon the judgment passed by Honorable Supreme Court reported in bracket 2009 bracket close 13 SCC 299 within bracket L.N. Avasthama and another SSP Prakash, and has referred to paragraph 17 and 18 of the said judgment to submit that the circumstances under which the plaintiff can take both the plea of claiming title as well as title and also adverse possession has been duly considered by the Honorable Supreme Court. He has submitted that since the entry in record of right has a presumptive value, the learned courts have recorded that the plaintiff has failed to prove his title by way of registered deed of the year 1956 on the grounds mentioned therein. Therefore, the claim of title on the basis of the sale deed does not survive anymore. Correct? Right?
This is what the courts below have.
Does not survive anymore in view of the findings recorded by the learned trial.
Because the two pleas are contradictory to each other, this is the finding.
That's right. This is the finding.
Yes, plea of
The learned counsel submits that in such circumstances, the title of the state stands and the plea of adverse possession by the plaintiff cannot be said to be inconsistent.
yes. My submission would be
Please, yes, please.
the
ये वाला कोड वाले को हाँ बताइए.
my submission would be that Your Lordship, both the courts have held that my plea of claiming title through Ladura Ho as well as claiming adverse possession against the state are contradictory to each other, and I could not have taken such a plea. This is erroneous in view of the law laid down by Honorable Supreme Court in the case of this
That should be
2009.
sufficient.
Yes.
The learned counsel for the appellant has also submitted that while referring to the aforesaid judgment passed reported in bracket 2009-13 SCC 229 has submitted that both the learned courts have held that the plaintiff had taken inconsistent plea by claiming title over the property through Ladura Hope and also claiming adverse possession against the state. He submits that such finding is contrary to the law laid down by the Honorable Supreme Court, reported in bracket 2009, 13 SCC 229, and accordingly, the finding recorded by the learned courts is contrary to the settled law. That's it.
Yes.
अब आपको कल बहस करना है. कल हम लोग कुछ रखें इधर 10:30 बजे ऐसे.
हाँ ये फर्स्ट केस है
Of course, as a first question.
एक रखते हैं इसके बाद से आइटम 5
आज से कौन सा केस है?
सेकंड
वो जो एब्सेंट है. ठीक है, पहले इसी को सुनिए.
ये जो अभी दिया है this itself a substantial question of law whether plaintiff can take
आप बहस करिए ना.
हाँ ठीक
आप बहस करिए ना. इन्होंने जितना बहस
हाँ,
किया है,
ठीक है,
मेरा
हाँ।
काम है उसको
नहीं
solve करना.
एकदम
और ये ऑर्डर अपलोड भी हो जाएगा, ज़्यादा लंबा बहस भी नहीं है.
ठीक
At the instance, the counsel for the respondents has prayed that the matter be taken up tomorrow. Honorable. Batch case. कौन सा batch case? आज का? कौन सा batch case? अच्छा.
डिफेंस स्टेट
हम आपको टाइम बताते हैं इसका टिकट करने का. We'll take it up at 12 o'clock. ठीक है, 12 बजे.
ठीक है 12 बजे के लिए फिर से सेकंड अपील
परसों कल. परसों ठीक है. परसों 10:30 बजे. ठीक है. ओके, डे आफ्टर टुमारो.
फिर एक 17 में भी परसों के लिए सो
इसके बाद Thursday. ठीक है. 10:30.
Thursday it may be the first so that I may be
10:30 बजे. इसको रखें.
ठीक है. हाँ.
आपके पास है ये इम्पोर्टेंट डॉक्यूमेंट है एग्जिबिट 5.
हम ले लेते हैं फोटो हमारे
जेरोक्स करके इनको देके.
हमने तो
और हमको भी थोड़ा ना डार्क करके जेरोक्स करके.
हाँ ठीक है, नहीं तो आई कैन गिव दैट आल्सो.
नहीं कभी मिस्टेक हो जाए.
ठीक है.
सर्टिफाइड कॉपी है ना,
ठीक है.
पुराना रिकॉर्ड के साथ कर.
हम तो फैक्चुअली अभी फोटो कराए पूरा मेरे पास वो भी जजमेंट दिस इज आवर बिजनेस.
चल.
Passover case item 2 asset 336 of 2004 I want to items 2.
वकालतनामा. सीरियल नंबर 3 में कहाँ है काउंसिल? ये जिसे वकालतनामा. Serial number 3 is कौन सा केस नंबर? 108. You are filing वकालतनामा on behalf of legal years of respondent number 12. You have filed a substitution. IA number?
IA number 7640 of 2020.
7640. When did he die?
On 31st August 2020.
Appeal number 12.
Yes.
2022, IA number 7640 of 2022, and IA number 8261 of 2022. In essay number 108 of 2005, the Learned Counsel for the appellant has submitted that appellant number 12 has expired on 31/8/2020, and IA number 7640 of 22 has been filed seeking substitution. The name of legal heirs have been mentioned in paragraph 1 of the interlocutory application. She has submitted that she has already received the wakalatnama and files the same of the legal heir and files the same during the court proceedings, which is taken on record. She has submitted that another petition seeking condonation of delay and setting aside abatement has been filed through IA number 8261 of 2022. Any objection?
No.
The Learned Counsel for the respondents has no objection so far as the prayer for substitution of respondent appellant number 12 is concerned, namely Karim Mia. Considering their posted submissions, the IA number 8261 of 2022 seeking condonation of delay in filing the petition for substitution and for setting aside abatement is hereby allowed. And so far as IA number 7640 of 2022 is concerned, the same is also allowed. The counsel for the appellant is directed to delete the name of the appellant number 12 from the cause title and insert the name of the legal heir and successor in their deed during the proceeding. आप इसको पढ़ेंगे और उसके बाद who has expired?
Respondent number 1.
The Learned Counsel essay number इसमें continuity में she has also submitted that the respondent number 1 in the present case has expired. However, respondent number 1 is the appellant in the connected case, being essay number 336 of 2004. And the legal heirs and successors of respondent number 1 is already available in the same record, right? You have to file substitution. How much time do you need?
2 weeks time, much.
2 weeks time has been. The council seeks adjournment for 2 weeks. Post on.
In serial number 2, petition for one IA is there for substituting that respondent number 1 in serial number 3.
वो substitution allowed नहीं है?
No, I is there.
कौन सा serial number 3?
Serial number 2 ना, the edition IA 1274.
Just serial number से नहीं बताइए, case number बताइए.
Check.
This is for substitution of?
Whose
Whose substitution? IA number?
12746.
This is for substitution of appellant number?
1. Govind.
उनका legal heirs का वकालतनामा कहाँ है? You will be appearing, no?
Right.
You seek the वकालतनामा. वकालतनामा लेके आइए. आपको response फाइल करना है. इसका क्या करना है? Substitution. आपके पास आ गया वकालतनामा? Have you got the वकालतनामा?
We will be filing it.
No.
वकालतनामा नहीं आया होगा तो फाइल कैसे किया होगा?
नहीं, वकालतनामा नहीं, वो ऐसे ही फाइल कर दिए हैं. क्या बोलेंगे? बिना वकालतनामा के फाइल किया. वकालतनामा फाइल करिए इनको लीगल यूज का. Manoj Yadav, the son, you are not holding his wakalatnama, you have filed a petition on his behalf. आदमी मर जाने के बाद तो वकालतनामा सर्वाइव नहीं करता है, तो खुद भी पिटीशन फाइल करेंगे तो बिना वकालतनामा के कैसे फाइल करेंगे? You get the वकालतनामा, देख लीजिए. You file the वकालतनामा, उसके बिना नहीं होगा. IA number 12746 of 2025 in SC number 336 of 2004. The Learned Counsel for the appellant Appellant has submitted that appellant number 1, dated back to Roman 2, Govind Mehto, has died
On 24.
on 24/2/2022, and therefore the petition has been filed seeking substitution. He submits that it is all likely that he would get the Vakalatnama on behalf of the legal heirs and successors, and if he gets it, he shall file it at the earliest. He prays for how much time?
2 weeks.
He prays for 2 weeks. The same day आएगा, right? Close this case on 13th October. दो आइए डिस्पोजल की हैं इसमें, एक सब्स्टिट्यूशन और एक लिमिटेशन.
Item 7, first April 37 of 2020.
Where is the appellant?
Respondent had died. She was the original plaintiff. She had died, and
It is clear that there's a change in the council right now, so we have to file the Vakalatnama in this matter.
Substituted.
substitution.
Change in council.
Yes.
You have not paid for any adjournment. Right?
Your ladyship means day before yesterday only she has got the client has got the NOC and we are going to file on Friday, so which hasn't been taken.
So no prayer for adjournment has been circulated. Why? There is no prayer for adjournment.
Ladyship just a week time we
क्या है सच्चाई की क्वेश्चन आपने पढ़ी?
नहीं ये तो फर्स्ट अपील है.
अच्छा फर्स्ट अपील. What is the matter about?
Matter was very simple otherwise. The plaintiff files a suit for declaration of right title interest, wherein we file a counter claim for our declaration because the property stood transferred in our favor by my father of the defendant, who was the husband of the plaintiff. Husband of plaintiff executes a deed of sale in favor of the appellant herein, who is the original defendant, and that is challenged by the plaintiff. She seeks a declaration and cancellation of the deed also, in which we file a counter claim. We say that on the basis of our deed, she must be evicted. We prayed for recovery of possession. Now, interestingly, the trial court dismisses the suit of the plaintiff, and it also dismisses my counter. So again dismissal of my counter claim, this appeal is there, but again the dismissal of the original suit, no appeal was filed. So their claim, the plaintiff's claim on the basis of whatever declarations she was seeking, that attains finality because it will be.
Paid the required court fees for counter claim?
Yes.
Written statement was filed.
It was
well contested.
Yes, but the trial court
Maybe
goes
lost
into.
sight of. Maybe lost sight of.
Yes.
Is there any specific plea in connection with counter claim? Any issue framed in connection with counter claim? Issue number 14.
Yes, it is there.
What is the answer to issue number 14?
It starts discussion of counterclaim in page 11, but
Issue number 14, all the issues are practically taken up together.
Few are actually connected to each other because issue number 10 onwards, actually issue number 12 onwards. 12 is whether the plaintiff is a licensee under the defendant or not. Because we had said that she was residing there with our permission. So this was one of our plea. Second was whether the license of the plaintiff was revoked by defendant on 28/2/2011. This is pursuant to the transfer to me by my father. Then 14 is whether the defendant is entitled to a decree for recovery of possession of the suit premises by evicting the plaintiff therefrom, to what other relief the defendant is entitled.
This will take time.
Issue number, all these issues have been, starts from page para
This will
12.
take quite some time.
Pardon?
It will take time.
Yes,
Because we have to understand the scope of the suit
yes.
and then only the scope of the complaint can be seen. इतना भी short नहीं है.
थोड़ा टाइम तो लगेगा, लेकिन your lordship, one fact would be very relevant. Otherwise, one release deed was there by this plaintiff in favor of the father of the plaintiff. That means husband of the plaintiff and father of the defendant. So what would be the effect of it? But it would take some.
It will take time. First appeal number 37 of 2020. Mr. Namatai,
Amish.
Mr. Avnish, advocate, undertakes to file fresh wakalatnama on behalf of respondents,
Yes, sir.
all the respondents,
Yes, sir.
on behalf of all the respondents, by tomorrow. At the prayer of the respondent, the matter is adjourned and directed to be posted on thirteenth October.
Under manual disposal or
We do not know, we are not in a position to say anything. 2020 ka hai, it will take time. The parties are directed to prepare short notes. This will take time, Mr. Bombay. इतना आसान
नहीं, उतना भी नहीं लगेगा because your lordship, 5 to 7 dates would clear.
How many witnesses are there?
Pardon?
How many witnesses are there?
Witnesses for?
4.
No. Your lordship, most of the fact would
Are
be
based on documents.
absolutely on the base of undisputed fact. Now the trial court says that there is a violation of section 46. Again, same question. Now, this could not have been because it was situated in the town Jamshedpur area, building constructed. How it becomes a Rayati land? So this is one question. Another, all these, strangely the trial court has gone somewhere else.
Final disposal on 14th. 14th October.
Item 8, first appeal 73 of 2020.
Your leadership, we have filed an IA 8386 and we are including subsequent purchaser of the party to be added by this particular IA. And for filing this IA, we have an order of 16K by 2025 in which we have been granted the liberty and hence we have filed this IA.
When did you purchase the property?
Your leadership, 5th by 7th of 2016, there has been a contract between the plaintiff and the respondents.
Contract. When did you file it? When did you are the intervener? Yes, you are, who are you?
I am the plaintiff.
Oh, you are the plaintiff. So why do you, when was this respondent number 3 purchased the property? What is the date of purchase?
Somewhere in 2018.
No, when did this respondent number 3 purchase the property?
23/5/2018. By sale deed number 3390.
And when was the suit filed?
In September 2020.
September 2020. It is 111 of 2018. Any objection? IA number 8386 of 2025. This petition has been filed seeking to increase the subsequent purchaser of the suit property, Srimati Jharkhand Singh, as necessary party as respondent number 3. The learned counsel for the appellant has submitted that she is the purchaser of the suit property by virtue of a registered sale deed dated 23/5/2018, and the specific performance of contract involved in the present case is relating to the contract dated 5/7/2016. Issue notice to the proposed respondent number 3. उनका details कहाँ है? Where is our details?
It is in the petition.
Show me.
It's in the
Where is it mentioned?
para 10.
Para 10 से ले लीजिएगा. For which requisites under speed post be filed. Speed post and ordinary process be filed within a period of 1 week from today. Post this case on 10th of November. It will be open to the respondent to file any response to the interlocutory application prior to the next date.